Welcome once again to our commerce classroom. In this session, we will discuss about Indian Contract Act 1872. We know Indian Contract Act 1872 is part of business law or mercantile law. So we start with the term business law. We know we apply business law in the field of trade, industry and commerce. So the term business law may be defined as that branch of law which comprises laws concerning trade, industry and commerce. I repeat, the term business law may be defined as that branch of law which comprises laws concerning trade, industry and commerce. It is an ever-growing branch of law with the changing circumstances of trade and commerce. With the increasing complexities of modern world, the scope of business law has enormously widened. It is generally understood to include the laws relating to contracts, sale of goods, partnership, companies, negotiable instruments, insurance, insolvency, carriage of goods and arbitration. The need for knowledge of law cannot be overemphasized. It is a common knowledge that ignorance of law is no excuse, which implies that it is not open to a person committing breach of law to plead ignorance of law. The main sources of Indian business law are: first one, English mercantile law; second one, the statute law; then third, judicial decisions and cases; and fourth, customs and usages. We discuss about all these. First source is English mercantile law. The English mercantile law constitutes the foundation on which the superstructure of the Indian mercantile law has been built. Second, the statute law. When a bill is passed by the parliament and signed by the president, it becomes an act or statute. The bulk of Indian business law is statute law. The Indian Contract Act 1872, the Negotiable Instruments Act 1881, the Sale of Goods Act 1930, Indian Partnership Act 1932, the Companies Act 2013 are instances of statute law. The third source of Indian business law is judicial decisions and case law. Judicial decisions are usually referred to as precedents and are binding on all courts having jurisdiction below the court which give judgment. And the fourth source, customs and usages. The custom or usage of a particular trade is also guides the courts in deciding the disputes arising out of business transactions. Then we discuss about Indian Contract Act 1872. The scheme of Indian Contract Act may be divided into two main groups. The scheme of Indian Contract Act may be divided into two main groups. First one, General Principles of Law of Contract, Section 1 to 75. And then second group, Specific Kind of Contracts. In it, Contracts of Indemnity and Guarantee, Sections 124 to 147. Then Contracts of Bailment and Pledge, Sections 148 to 181. And then Contracts of Agency, Section 182 to 238. I repeat, the scheme of Indian Contract Act may be divided into two main groups. First one, General Principles of Law of Contract, Section 1 to 75. And then second group, Specific Kind of Contracts, Contracts of Indemnity and Guarantee, so Section 124 to Section 147. And then second one, Contracts of Bailment and Pledge, Section 148 to 181. And then third, Specific Kind of Contract, Contract of Agency, Section 182 to 238. Then we discuss the term contract. Contract is defined under Section 2, subsection H of Indian Contract Act. A contract is defined as an agreement enforceable by law. I repeat, a contract is defined as an agreement enforceable by law. So we can say that in a contract there is an agreement, and secondly that agreement should have legal enforceability. A contract therefore is an agreement the object of which is to create legal obligation, that is a duty enforceable by law. The two essential elements of contract are first one agreement, second one its enforceability. Section 2 subsection E defines agreement as every promise and every set of promises forming consideration for each other. That is what agreement. Section 2 subsection E of Indian Contract Act defines agreement as every promise and every set of promises forming consideration for each other. In other words, an agreement is formed where one party makes the proposal and the other party accepts it. I repeat, an agreement is formed where one party makes an offer and the other party accepts that offer. I will repeat the definition of agreement. Section 2 subsection E of Indian Contract Act defines agreement as every promise and every set of promises forming consideration for each other. So agreement is formed where one party makes the proposal and other party accepts that proposal. Then second element of contract is enforceability. Only an enforceable agreement can be called a contract. I repeat, only an enforceable agreement can be called a contract. Section 10 of Indian Contract Act defines all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and a lawful object and are not hereby expressly declared to be void. I repeat, Section 10 of Indian Contract Act defines all agreements are contracts if they are made by free consent of the parties competent to contract for a lawful consideration and a lawful object and are not hereby expressly declared to be void. These are the two essential elements of a contract. Then we discuss about essential elements of a valid contract. Essential elements of a valid contract. The following are the essential elements of a contract arrived at on the basis of combined readings of Section 2 subsection H and Section 10 of Indian Contract Act. I repeat, the following are the essential elements of a contract arrived at on the basis of a combined reading of Section 2 subsection H and Section 10 of Indian Contract Act. The first essential element of a valid contract, offer and acceptance. First essential element, offer and acceptance. There must be a lawful offer and lawful acceptance of the offer, thus resulting in an agreement. I repeat, there must be a lawful offer and lawful acceptance of that offer, thus resulting in an agreement. Example, if X offers to sell his house to Y for rupees 10 lakh, here X makes an offer and Y agrees to pay to X rupees 10 lakh for the house. Y agrees to pay rupees 10 lakh for that house to X. So Y accepts that offer. Here X is called the promiser or offerer and Y is called the promisee or offeree. This is the first essential element of a valid contract. I repeat, offer and acceptance. The second essential element of a valid contract is intention to create legal relations. There must be an intention among the parties that the agreement should create legal obligations. The agreement should be attached by legal consequences and create legal obligations. Example, A promises his wife B to get her a sari if she will sing a song. B sang the song, but A didn't bring the sari for her. B cannot bring an action in a court to enforce the agreement as it lacks the intention to create legal relationship. The third essential element of a valid contract is lawful consideration. An agreement to be enforceable by law must be supported by consideration. Consideration has been defined as the price paid by one party for the promise of the other. Without consideration, a contract is regarded as nudum pactum, means bare promise. Each of the contracting parties must give as well as get something. Moreover, the consideration must be lawful. Example, X lets his house for being used as a gambling den. The agreement is illegal as the object of agreement is unlawful. Fourth essential element of valid contract is capacity of the parties. The parties making the contract must be legally competent to contract. According to section 11, legally competent in the sense that each must be of the age of majority, of a sound mind, and not expressly disqualified from contracting by any law to which he is subject. An agreement by incompetent parties shall be a legal nullity. And the fifth essential element of a valid contract is free consent. The contracting parties must give their consent freely. The contracting parties must give their consent freely. Consent means the parties must have agreed upon the same thing in the same sense. Consent means the parties must have agreed upon the same thing in the same sense. There is absence of free consent if the agreement is induced by coercion, undue influence, fraud, misrepresentation, or mistake. I repeat, there is absence of free consent if the agreement is induced by coercion, undue influence, fraud, misrepresentation, or mistake. The absence of free consent would affect the legal enforceability of a contract. Example, an illiterate woman executes a deed of gift under the impression that she is executing a deed authorizing her nephew to manage her agricultural land. The deed is not read or explained to her. Here, there is no consent, therefore no contract. Sixth essential element of a valid contract is lawful object. The object of the agreement must be lawful. It is considered unlawful if it is illegal, immoral, fraudulent. If it is permitted, it will defeat the provisions of law, causes injury to person or property of another, opposed to public policy. Example, X promises to obtain a job for Y in government service in consideration of rupees 1 lakh. The agreement is void because it is forbidden by law. Seventh essential element of a valid contract is writing and registration. According to Indian Contract Act, a contract may be oral or in writing, but in some special cases, it must be in writing and registered. Example, agreement to pay a time-bound debt, agreement to make a gift for natural love and affection. In these cases, agreement must be writing and registered. Eighth essential element of a valid contract is certainty. The terms of the agreement must be certain and unambiguous. Section 29 of the Act, agreements the meaning of which is not certain or capable of being made certain are void. Example, A agrees to sell 100 tons of oil to B. There is nothing whatever to show what kind of oil was intended. The agreement is void for uncertainty. Ninth essential element of a valid contract is possibility of performance. possibility of performance. Section 56 lays down that an agreement to do an act impossible in itself is void. If the act is impossible in itself, physically or legally, the agreement cannot be enforced at law. The 10th essential element of a valid contract is not expressly declared void. Not expressly declared void. The agreement must not have been declared void by any law in force in India. The Act has itself declared void certain types of agreements, such as those in restraint of marriage, in restraint of trade, in restraint of legal proceedings, as well as wagering agreements. I think this session handled here the definition of contract and essential elements of a valid contract clear for all of you. We will continue our topic in coming sessions. Till then, goodbye.